Mr. Ndlovu, and I'll be taking you through the examination techniques for business law, which is DA6, offered by Zica. I will guide you as to how you should best approach the examination of this paper, and you do not need to fail actually. So your mind must be set towards passing this course, and I'm here to guide you. So the key point for you to understand is that the exams are not basically difficult, okay? They are not. You are able to actually sit for them and clear them. Your colleagues have done it and you also do it. This you must always know, okay? And the key points are that the exam which you'll be sitting for is basically anchored on the Zica manuals, which are already available for you. So my key starting point as I give you guidance is that the moment you enroll for this particular course, you have to ensure that you have got all the requisite material and you start studying. But now we'll look at the mode of study as to how you study as you prepare for this examination. And I'll give you the key necessary, okay, techniques needed for your examination. What you have to understand is that you are dealing with business law, right? That is to say, the laws which regulate business activities. This is very important for you. You have to understand that there are certain laws which have been provided for which regulate business operations, and these laws are basically laid categorically in line with the Zica syllabus. You have to address your mind with that, and you should not address yourself or maybe approach these exams as a student. No, these exams are basically tailor-made for industry use. So approach them as a practitioner, okay? With somebody who's already done, who's already right there in the industry, who understands what he or she is doing. What the exams basically will be set along that path. And it is a requirement that you approach them with a level of maturity and practice. Okay, these are practical examinations and you have to approach them in that regard. Because what employers are looking for, they are not basically looking for somebody with a paper only. Okay, having a paper is one thing and performing is another thing. And you can only perform if you understand what you've done. Okay, so for instance, let me just run you through the syllabus of the key topics which you're supposed to understand. If you look at the Zica manual, the first topic is basically essential elements of the Zambian legal system. Okay, essential element of the Zambian legal system. Underline that. Especially the term essential. Meaning that these are very key. Remember, I've said that we are dealing with the laws regulating businesses. Okay? And then the first topic is basically essential elements of the Zambian legal system. So you as a Zica student and the candidate for this particular paper, you are supposed to understand the essential elements of the Zambian legal system. Okay? As legal system is basically the manner in which laws are administered in a particular community. And now the community has been narrowed down to a business sector. Okay, there are do's and don'ts which the laws have eventually provided for, which you as a candidate must exhibit to clear this course. Okay, then the other topic which you're supposed to fully understand is that on the law of obligations. Okay, the law of obligations is without doubt part of your examination. If you're writing or if you intend to write, you'll find it. So you're supposed to understand key issues surrounding the law of obligations. I'll give you just a snapshot breakdown for each topic soon. And then the other topic is that you're supposed to understand contracts under the Sale of Goods Act. Colleagues, this is very important. Okay? Understand this. Law of obligations is basically dealing with contracts. That's simple. Contracts, right? However, contracts under the Sale of Goods Act are so peculiar. Okay? The Sale of Goods Act itself, which regulates the contracts under the Sale of Goods Act, has made guidance, okay, available for you as a student as to how you should understand how those contracts are supposed to be couched. Because in industry, as you do your duties, you will come across what may appear to be a contract of sale, okay, or what are actually contracts of sale. You discover that, as by way of comparison, that a contract of sale is concluded the moment the goods are certain to the contract, or the moment you identify the goods. Okay? For instance, I'll give you this example. Okay, let's say Mulenda Banda decides to enter into a contract of the purchase of some giraffes from Kafue Estate, okay? And then he does a head count as they are running to and from, okay, in the bush. Will that contract really suffice and stand that law? If you look, for instance, at a contract of sale, here is a good example. I will give you, let's say Mulenga enters into a contract with Kafue Safaris for a purchase of 50 giraffes, okay? And these giraffes are not in a cage, okay? They are not maybe caged or secured in a place where they are not moving up and about. He enters into a van and you start doing head count while they are moving about in the bush. The danger of such is that there is high risk of repetitive counting, okay? You are able to even to count one giraffe 5 times if you're not careful. So the law requires that such animals be appropriated to the contract. Now how do you appropriate them? We have to shoot at them using a non-harmful, okay, gun. So maybe they fall asleep. You count them. They should be counted individually, selectively, one by one, okay? If you are buying, let's say, maybe 500 bags of maize from FRA, and in the stores there are about 2 million bags, okay? Such a contract cannot just be concluded by you looking at the bags in the warehouse. Your 500 bags must be removed from the rest, one by one. You do an individual count. Once you count and you agree with FRA, even by word of mouth, that these, you have seen them, you have identified them, the contract is concluded at that particular point. It is immaterial that you have not paid FRA. No. FRA, you discover that under section 26, okay, and under section 24, you read also section 18 of the Sale of Goods Act and the rules thereof. Very important, okay? You discover that the contract, or maybe the property in the goods under a contract of sale moves, okay, the moment the goods have been appropriated to the contract. By property in the goods, I'm simply referring to title. It's a legal language, okay? The property in the goods simply refers to title. So at what point is a contract under sale of goods concluded? The moment the goods have been identified. You come to me, you want to buy my phone, I show you the phone. Here are the specs. How much is the price? 2,500 kwacha. Once I agree that I'll sell the phone to you, minus you even paying me even one way, a contract has been concluded. Okay? These are special contracts under the Sale of Goods Act. The property in the goods moves immediately, okay? The goods have been appropriated or identified with the contract. What is there for the consideration? The consideration, if you look at the definition section of the Act, okay, the consideration thereof is the price, okay? It is immaterial that you have paid me or not. Once you have agreed, contract is concluded. But now in simple contracts, okay, the day-to-day contracts which you enter, where there's offer, acceptance, consideration, those are key elements. Those are simple contracts. So you should be able to distinguish as a student. If you see fact that there was a sale, okay, don't rush to say that, no, this was a simple contract. Read the fine lines in between. The devil is always in that detail in this course. So address your mind to the fine lines and draw a distinction from simple contracts to contracts under sale of goods. If you discover that this is a contract under sale of goods, please apply the principles and the rules under section 18. I will advise you as a student preparing for this examination to read all the rules, rule 1 to 5. So explicit. If you read that, we are done with the Sale of Goods Act. Just section 18. And if you so decide to look at the contracts, maybe at the Zica manual, you'll find that those rules are there, categorically put for you, for your understanding. They are not just for packaging or for design. They are there to help you pass this course easily. Okay. The other thing we are supposed to look at here is employment law. You see, employment law, again, this is another type of contract which is brought to the fore, but differently. This is a contract now between the employer and the employee. It raises obligations of both parties. Okay? The employer has obligations, the employee has obligations. Some of these obligations, especially the highly examinable one, they are common law. Yes, common law driven. Of which they are there in the Zica manual. Okay? So address your mind to how a contract of employment is entered into. Okay? Once you identify that this is a contract of employment, what's their breach of that contract? which led to the dismissal of that particular person. Or maybe in the alternative, okay, such a contract, if it was orally entered into, what are the legal implications of such? Because you, as a student, you are being trained not to remain a student, but to advise industry, as they are, maybe to advise industry players as they are running their businesses. Meaning that you must advise them to desist from having what? Oral contracts. Let them reduce them into writing. Okay, in case an argument or a dispute arises tomorrow, an employer will not have anything to really lean on, because what is not evidence in writing does not exist. Okay, he who alleges must prove the allegation. Now, how do you prove it if the contract is by word of mouth? It becomes very difficult. Okay, but you as a smart student who has been trained by Zica and you are now ready for industry, always insist that all contracts are basically entered into by way of writing. Reduce them. And if need be, have them attested at the Ministry of Labor. By so doing, you as an employee are actually protected. But if you're an employee and it was just by word of mouth, you may end up losing out on some of your benefits because there is no proof to show that you're actually employed. Okay, so that's another area. But for exam purposes, what are the key issues regarding employment contracts, which are supposed to address your mind to? Okay, look at the formation, look at the way the law regulates such contracts, and the one which is always part of your exams. This one doesn't miss. Forms of maybe contract termination for employment. Okay? How does a contract of employment come to an end? That one is always part of the exams. You check all the papers and so forth. You find that you students, you normally fail to distinguish unfair dismissal, okay, from unlawful dismissal. These terminologies, lecturers play around with them because they know that you don't pay particular attention to detail as you are studying. There's just a thin line between the two. You miss one word or two words, you're failed. Okay, so this guide is meant for you to understand how you approach these topics. Okay, the next topic which you're supposed to understand is agency law. Simple. In your mind, you must always have the definition of the law of agency. Okay? Agency is basically whereby somebody decides to act through the other. Okay? Okay? If I decide to act through you as my student, I say, okay, I want you to act on my behalf. You go to Nakonde and pick up my vehicle. Right? You, my student. I've decided to give you that assignment. And then you agree, we reduce it into writing. Now that you know that such contracts must be in writing, okay, I'm basically giving you some authority to act on my behalf. Okay? If I'm in the UK, okay, yes, I decide to contact you in Zambia. I said, do this for me, or do a conveyance for me, do this transaction for me in this land area. I may need to give a power of attorney to act on my behalf. Are we together? So, if you are acting on my behalf, you are executing those duties on my behalf. Technically, okay, you are acting in my best interest. So the law demands that if such a thing has happened, you, my student, you must act for me and on behalf of me and exhibit high levels of due diligence, skill and care, okay, of which myself also on one hand, I have also some obligation, that is to pay you, okay, and also to indemnify you. Now, this term indemnification must be understood what it means. Are we together? So, I'm supposed to only indemnify you in the event that you were maybe caught up in a mix during the execution of your duties. Okay? Under my authority. Remember, I may hire you as a natural person. Please get this right. Myself as a natural person, as a Mr. Love, I may hire you to go and pick up my car in Nakonde. Okay? When you deliver it back home to me, I have to pay you your commission. Okay? That's what we refer to as remuneration. So you are acting on my behalf. But let's say I decide to incorporate a company. The company is DD Limited. And we hire you, maybe under the name DD Limited, to go and get the vehicles from Nakonde and bring them back to the company premises. Okay, I may have called you as a director of that company, but the contract is not between me and you. Hear me very well. Once a company has been incorporated, it becomes a persona at law. It is a person. It can do what it can do. Okay, it can own assets. It can sue and be sued. Are we together? It owns money. Okay, so if we incorporate the company there, dear students, and it is a limited company, then you move around with the ATM card of a company in your pocket. That is wrong. At law, that's not how you do things. Okay? There must be proper documentation. Okay? There must be annual returns. Everything. You must comply with all those as a business smart student. Okay? So now, if you are getting those vehicles on behalf of DTT Limited, what is expected of you is that maybe you are on transit from Nakonde to Lusaka. Now you are by Chisamba there. You happen to veer off the road because you've lost control, and you bash the tables of some women selling tomatoes along the road. Fortunately enough, nobody has died there. Okay? And they decide to sue you for all their tomatoes for the harvest for 2020. Okay? You as a person, because you are acting within the scope of your duty, the agent is basically liable, quite all right. But the primary liability lies with the company, which sent the agent. Well, the agent must be indemnified, okay? Offer some protection. So a company will have to pay for the costs. And then under the principle of subrogation, most companies now start deducting the losses from the employee if the employee was careless or if the employee acted negligent, slowly. But you see, you have some indemnification. However, in one of the cases which you find in the Zica manual under this topic, I implore you that you start looking at these things today. Okay, one of the key issues which you're going to find, if let's say you're a driver of maybe my bus, okay, and then you happen to chase maybe another bus, okay, so that you can get passengers quickly at the station. You know what happens, students, you have seen it. At times they even drag you by hand from some meters from your bus station, okay. So when such a thing happens, if let's say in the rush of trying to get most clients, okay, my driver happens to bash somebody, still I myself as the owner of that bus, I'm liable, okay. That's where now the principle of vicarious liability comes in. Okay, I am actually vicariously liable for all the omissions and commissions of my agent. Are we together? So you must have this mind. Who is an agent? What are the liabilities of this agent? Okay, what are the responsibilities of this agent? And what also are the responsibilities of me as the principal? Okay, this you must always have in mind. I hope that is very clear. I want you to focus your mind to all these issues which I've just highlighted. You are supposed also to look at the law of torts. The syllabus is very clear. It's guiding you there. So the law of torts, okay, this is basically, these are omissions committed by citizens towards each other. Okay, the state is not involved here. And it's not a contract. Okay, contract, there must be consensus ad idem, meeting of the mind. There must be some meeting of the mind somewhere. I'll look at that shortly. But for torts, these are omissions whereby they are committed minus you not having an intention to commit it. But you commit it, and it occasions some harm to the plaintiff, the other part. Suffers damage. They have to sue you. Yes, they will sue you as my student. Let's say you decide to manufacture Manzi Valley because you have discovered that due to COVID-19, supplies have stopped coming to Matero, wherever you are. Okay? Then you decide now to manufacture your own Manzi Valley, right there. And then you pump in with tap water, and some of the water is not purified and so forth. And then innocently, your fellow student also comes and buys from your shop, and then they fall sick. Okay. You'll be sued for negligence by the person who has fallen sick. Okay? If also the Manzi Valley proprietor, the main company, finds out, they will sue you under the threat of passing off. Okay, so these are omissions. Okay, there is no specific written law which has been breached here, as opposed to criminal issues and contracts where there's an agreement and so forth. No. Are we together? So have that approach as you are dealing with these courses. And then the last topic I want you to really pay attention to is on partnerships. Listen, a partnership can be entered into by natural persons. It can also be entered into by artificial persons. I've already said it. Artificial persons, these are companies which have been incorporated. For instance, Butter Shoe Company Zambia Limited, by way of example, okay, may decide to enter into a partnership with maybe ShopRite Checkers Limited, okay? Yes, and then the terms of conditions of that partnership, okay, are going to be expressed ideally in the partnership deed. And for this regard, find yourself a partnership act, okay? In the Zica manual, key sections have been highlighted, defining a partner, the duties of a partner, liabilities of partners, okay? They've been defined in the Zica manual, they are there. But if you want to have the whole act yourself, those are free. Just go to the Parliament website, download one. They're there for free, okay? So now that I've run you through the syllabus of what is expected of you, I expect that now, as you're preparing for your exam, you cover topic 1 to topic 7, all of them. Do not omit anything. Cover to cover, because the exam is basically going to encompass everything which is in the Zica manual. Avoid selective study as my student. Do not engage in such. Okay, so I would expect you to understand the syllabus coverage first. Okay, a farmer who prepares on time is guaranteed of a bumper harvest. So start your preparations now and do so. Look, preparation is key for this exam. It is very much important that you prepare yourself. Adequate preparation is key. Attention to detail is key. Case analysis, as you're studying, is very much important. In fact, most of the scenarios which you find in the exam, they are derived from cases. Remember on sources of law, on your unit 1, you can check it out even right now. Unit 1, you find that one of the sources of law are what we refer to as precedents or judicial decisions. Yes, they are sources of law. And the source of law by definition is where you find the law. Where do you find the law? In law, we say a lawyer who knows where to find the law is a good lawyer. Okay? So, since they are being trained on the legal aspect of it, of conducting a business, each business must be conducted within the confines of the law. Okay? You are supposed to understand the sources of law. Where do you find the law? The Partnership Act I mentioned, that's a source of law. The Sale of Goods Act is another source of law. These judicial decisions is another source of law. Contract law, dear colleagues, if you don't read your cases, you are doomed. So I will expect you to read cases. Now you may be asking me, sir, I've been citing all those cases and the facts and everything in the exam, but I've been failing. Yes. If you're not guided properly as to how to deal with cases, you will cite them in the exam and then you will fail. But I'll show you how to narrow it down in an exam situation. But what you're supposed to always have at the back of your mind is that you're not supposed to regurgitate all the facts. Just bring out the case, the principle, and the application. Application part. Where do you apply that case? You apply the case to the facts brought before you in the exam room. Listen, all those scenarios you find in the exam room, take them as your client. Your client has come to you. This is what happened. Advice. Are you sure you are ready to advise, or you have to start preparing quickly before the next maybe visit by your own client will be in the form of an exam? Yes. But those exam scenarios are derived from actual industry experiences. And most of them, they are derived from the cases, the case law. Okay? So if you read a lot of cases, lecturers have this tendency of going to a case which they've given you, or which is actually in the Zica manual, and you pick up all the facts as they are. Yes. And just fine-tune here and there, change names here and there, but the facts are the same. If you understand the principle, you have an A+ for yourself. So read the Zica manual and the cases which are there. They are not meant for decoration. They are meant for you to read. Like I said, you are being trained for industry. And you are supposed to rely on the sources of the law. And case law is one of them. Okay? So, you are supposed to apply the principles to the facts. You will be given facts. So, preparation is key. And how do you prepare? Okay? Have this in mind that you are well able and you clear that paper. Okay? And pay attention to detail as you are studying. Analyze all the cases and know them. Pick out the principles. Okay? And then rely on the effective study aspect. Because preparation is just key. You cannot wait until a month before the examinations. That will be suicide, students. Don't wait until a month before examinations. I've given you topics which are loaded, which I will try and break down in a few minutes, but that does not mean that they are that simple. Okay? They only become simple if you read. Okay? There's always something which will make you remember if you read something in the exam. Something will make you remember. Okay? The key is for you to read. And I always encourage my students that get the Zica manual, read it from cover to cover, at least 3 times before the exam. But not the week before, no. Start now. Okay? If your exam is exactly in 6 months, start reading now. If your exam is within a year, start reading now. And you'll be good to go. You know the problems. Adequate preparation is key in this course. Okay? Never wait until a month before the exam for you to pass, and avoid selective studying. Because some of you, once you get a paper from Zica, you always have it in your mind that you are going to answer questions on this area, and then you avoid questions on this area. That is a high risk. It's a huge gamble. Avoid that. What I want you to do, get the manual, read it religiously, okay? As somebody who wants to offer help to the industry. Like I said, the employers really have moved from just looking for papers. They want people who know their stuff. Yes, that's what an employer is looking for. Okay? Why should I hire you? And then every day I'm busy advising you on what to do. You should know what to do. That's why you are studying. So after studying, you have to be done. Okay? That's what is required of you. Okay? The selective studying, no, rule it out. Now, if you are dealing with cases, analysis of cases is actually essential for understanding key elements in this course. Like I said, do not regurgitate facts. All you need is to state the case, the principle, and you apply it to the facts before you. Okay? For instance, I'll give you this example. Charles and Muvanga decided to go to showgrounds during an auction, and the auctioneer started the bid from 20,000 kwacha. Okay? He was auctioning off a motor vehicle. Muvanga stood up and said, yes, 60,000 kwacha for the vehicle. The auctioneer noted his hand in agreement and said, wait a minute, I love your offer. I think I'll offer you this. Okay? Then Charles stands up and says, I've got 150,000 kwacha cash. Close that deal. Okay. Then the auctioneer just walks out from the podium and says, Charles, the car is yours. But it was an auction. Okay. Now, the auctioneer decides to sell the car to somebody else for 250,000. And now Charles and Mwanga have sued the auctioneer for breach of contract. Advice. These are the questions which you will find. But colleagues, the answer is just in one case. Pain and cave. As far as auctions are concerned, when the javel falls, okay, that's the hammer which the auctioneer has used. Once it falls, the contract has been concluded. So from the facts I've given you, there is no mention of the javel falling. Don't manufacture your own facts in the exam. And don't rely on assumptions. Use strictly what is there before you. Are we together? Please, use strictly only that which is before you. Do not manufacture facts. Some of you assume that maybe a lecturer left out something. No. The scenario question is actually adequate. It is enough for you. Okay? So please follow that. And if you are to answer such a question, let's assume that you have read Pen in the Cave. You say, okay, from the facts at hand, that's how you approach. Okay? It can be said that all auctions, okay, are basically invitations to treat. Right? An invitation to treat is defined as blah, blah, blah. That's you now. Okay? So in the case before us, it can be argued that a contract was never formed, as an auction simply amounted to an invitation to treat, and the javel was never fall, as was seen in the case of Payne versus Cave, where the court guided. If it has 10 marks, you get all of them. Yes. Yes, that's what the examiner looks for. I'm not even saying that bring out the facts of Payne and Cave in total. No. The principle in Cave, look, the principle in Payne and Cave is that a contract is concluded at the fall of the arm. How do you get it? That's the main principle. So, you cite the case in the exam, that is Payne and Cave. What's the principle? A contract is concluded at the fall of the hammer, right? Then now you apply such a case and principle to the facts. In your facts before you in the exam, did the javel fall? If the answer is no, there was no contract. You have studied the case, you have advised the parties, are we together? And you've earned all your marks. So please do that in the exam. Now what I'm saying, you should read the cases. The ones which are in the Zica manual, they've been summarized for your own cause. Okay? They've been summarized. All we want for you is just to bring out that principle. Okay? So you may be asking me, so sir, how do I start these cases? There are too many. Okay? Always employ only effective study methods. With the advent of technology, some of you may be tempted, your WhatsApp is on, you are checking your Facebook, you're WhatsApping, and you say that you are studying. That's a joke. You can't do that. If you say you want to study, I want you as a student from today. If you say you've got 1 hour, 30 minutes, listen, the biggest capital which you have under the sun is just your time. If you say 1 hour, 30 minutes is for my studies, switch off your phone. If you don't want, put it on silent and put it away from you where you visit after an hour, 30 minutes. Then start studying. Okay? Your phone must be off during study. Don't even look at it. Yes. Or put it on silent, put it in your bag, and the bag must be far away from you until your 1 hour, 30 minutes is done. So if you study for the first 20 minutes, you can break for about 2, 3, 4, 5 minutes. Then get a plain paper without looking at what you study. Try to remember, write down what you studied. If you recall everything, after writing down, check with what you've been reading, whether what you've been doing has been done, or you've understood the topic. If you don't do that, you may think that you've really studied, and only to discover that you're busy chatting, you didn't understand, you're just flipping the pages. So I want you to have that approach. You can't study law without having a paper and maybe a book where you're busy writing your own notes. Write your own notes. Yes, the Zica manual is good. Very good. But from the Zica manual, develop your own notes, which will make you remember key issues. Okay, so do that.
Whether you're laying down foundations for your business or restructuring market goals, it's important to have professionals that you can trust. Chartered accountants are key to business growth to help you bring your ventures to the world. That's why you should make sure you have a CA Zambia on board. CA Zambia is a globally recognized chartered accountancy qualification that ensures our chartered accountants uphold international standards and stay informed on the best accounting practices worldwide. Keep your business growth healthy. Go with a CA Zambia certified accountant. CA Zambia, developing business leaders.
And use flashcards. Huh? Flashcards, you don't even need to buy them. You can prepare yours. Okay, make your own flashcards. Yes. Indicate the key issues and principles per topic. Have some flashcards. You can do that. Okay, identify keywords in each and every topic. Do that. What are the keywords in a contract? Okay, for one to say the contract was formed, or for you to say that was a breach of contract, it means that you have to identify that was a contract formed in the first place. Now, how do you know that that was a contract formed? You must look at the definition and the elements of a contract. Okay, I will look at that shortly. So, also as you're studying, try to have some group works. Find a study group. Maybe once a week, discuss weekly tasks in the manual and past papers. That's what you're supposed to do. Okay? Ensure to discuss key principles and concepts in all given topics. Ask your friends. You can even co-assign each other if, let's say, it's a collaborative study approach which you've undertaken. You can do that. Assign you, go teach, look at agents, you come and teach us tomorrow. But look, once you do that, you will be taught maybe the following day. Must also study the topic, or else your friend will come and mislead you. So that gives each of you pressure to study, okay, and be at the same page. I want you to try and do that. And once you study a topic, ensure to look at the Zica study kit. Do that. And pick a question on that particular topic, attempt that question, and always have in mind case, principle, application. Okay, the rationale for doing this is to basically apply the knowledge which you have attained to real life situations. Then we can call you educated. You see, in view of what is happening currently with this pandemic, I think if a doctor says that they are certified, they are doctors indeed. Okay? They can just go to the hospital, they start reading theory to you. They should work on you as a person. Well, they've been trained for years to do that. Okay? So look, by the same token, if you are hired at a company, if you are running your business, and maybe it's a board of directors sessions, you cannot start telling them, no, in pain and care, it was held, blah, blah. They don't understand those things. What they want is a sound business advice from you, as somebody who has been trained. No, look, if we do this, we'll be committing a tort. If we do this, we'll be sued for this. That's what employers are looking for. For us to avoid liability, let's do this. Let's do this. Let's do this. Even yourself, as you're running your own business, inculcate all these principles, and you'll be okay. Time management is key. Remember I said, as you are doing your studies, allocate time. Do that without fail. Remember, time management is part of the examination. And that time begins now before you sit for your final examination. Yes, manage your time very well. And even as you are looking at the Zica past papers, don't write a 3-hour paper in 10 hours. Okay? Usually I tell students to do this 2 months before the exam. Get a full paper. 2 months before the exam, attempt it. After attempting that paper, under 3 hours, if 2 hours, 59 minutes lapses and you have answered only 4 questions, stop. And mark yourself out of those 4 questions. How do you then mark yourself? Refer to the sample solutions which are on the Zica website. So when you are studying, don't go directly to the sample solutions. No. Study the topic from the Zica manual, get a question paper and attempt it, then you mark yourself. Do that 4 or 5 times. You'll be an A+ student. Because, look, we lecturers do not manufacture things. We follow the Zica manual. That's what we do. Yes. Yes, it's the Zica manual. Some of you know these exams are very tough. They want to fail us. Really? It can't be. The principles are the same. Okay? Your colleagues cleared it because they follow these principles. Read, revise, attempt exam questions, and you'll be good to go. This I always tell my students, and I will tell you as well. Okay? Do not study the whole night before the examination. Yeah. There's some of you would break nights when doing other certificate courses here and there and so forth. When you are studying for a professional course, you don't study the whole night before the exam. You crash. You start mixing facts, maybe from Khalid and Kabuluk Smokebo. You're citing them now on the hide and range where there's a counter off. Don't do that. Study on time and prepare on time. Then you'll be good to go. And if you're going for an exam that day, go for an exam, at least arrive 15 minutes before the exam. Be composed. Panicking must be avoided at all costs. Okay? If you know, you know. If you don't know, you don't know. That's just the truth. Yes. So, prepare on time, arrive for the examination on time, and you'll be good to go. Okay? And when it comes to exam time management, these are just general tips for writing the exams, right? Read the instructions carefully and follow them to the letter. Yes, read the instructions carefully and follow them to the letter. What I've observed even as an invigilator at some point, you students don't read the instructions. Yes, most of you just flip what is question 1 all about. You want to see whether what you've been gunning the whole night is actually in the paper. That's wrong. The starting point, read the instructions. Yes, what if maybe Zica decides to give as an instruction, which will say, for this session, answer nothing. And you see simple questions, you answer everything. Trust me, the failure will be so high. Because the instructions answer nothing this time around. So you just have to sit for 3 hours. After 3 hours, you walk out. Yes. At times you may find that maybe you've been requested to answer the whole paper or just answer 1 question from section A and answer any 4 from section B. And section A has 3 questions. But look, these papers, they evolve. Things change. Okay? So, always read the instructions. Instructions are part of the exams. Failure to read instructions is total failure from the beginning. Read those instructions. Instructions are part of the exams. And I always tell my students that the compulsory question normally should be looked at last. For this course, you've got multiple choice questions in the compulsory question. I advise you to look at them last. Be composed, okay? You enter the exam room, be composed. When they say look at your paper, read the instructions first, then you go to section B, choose easiest questions. Don't go for tough questions. Don't be a hero, no. Choose simple questions, and if you pick a simple question, what you're supposed to do is look at the marks weightage. If it's carrying 10 marks, do not write 5 pages. Write about 2 or 3 pages. If it's carrying 2 marks, maybe a paragraph will do. Okay? Not because that maybe you have nothing to write. If you see yourself writing 4 pages on a question carrying 4 marks, you've already failed. What are you writing? Okay? So you're supposed to look at the marks weightage and then you answer the question. And please answer the question. Don't give a general story and say that they will mark me because I've said this and I've said the case. If you're citing a case, is that case relevant to the question before you? Yes, always ask yourself this question. Is this case relevant? If the answer is no, don't cite it. Don't just quote everything you come across. Answer the questions. It is very important, colleagues. I hope you implement that as you are preparing for your exams. Because look, compulsory questions are usually meant to throw you off. Okay? And like I said, pick the easiest questions. Okay? Divide your time with the questions before you, but always leave about 40 to 50 minutes on question 1. Do that, and you'll be safe. Okay? And how can you achieve this? Do not overwrite on what you know. You find one question, you really overwrite. And then instead of answering 5 questions, you won't answer 3. Do you realize that you've already marked yourself off 40 marks? Or off 20 marks when you both have answered 4? Answer all questions. The instructions are clear. Attempt all questions. Do that. And you will get your 50. You'll be okay. Okay. But that should not be the primary objective. Try and aim as high as you can. And also read to know, not to pass. Because industry will demand you to know, to exhibit knowledge. And this is what Zica is basically doing to you. Okay. The other issue is handwriting. Handwriting is key. Okay. So as you are doing your sample exams at home, dummy exams, which you have to be honest with you after marking yourself. I remember I did one at some point, and the first one when I was checking with some solution, I found that I actually earned less than 50%. Then I had to read again. The following day I attempted it, I was marking myself honestly, and I was 60% somewhere there. And I did that continuously because that was a central topic, okay, to the course study, which I was doing then. In the exam, I found that the course study was brought in the exam. And I was smiling. I even knew that it's an A+, come at me. And it came as just like that. So you can prepare, you can even know, okay, I failed this course or I passed this course. You can actually know. But the most important thing is, let your handwriting be clear, be neat, do your best, okay? So when you're dealing with multiple choice questions, let's say you're done with section B, and you come to multiple choice questions. Let me tell you one trick. Examiners, they will set a multiple choice question, and they will give you solutions which are very similar. So the best approach here, use the elimination method, and then you remain with one possible good answer. You'll be good to go, you will get 20 marks from there. But if you're using gamble, it's 50-50. Okay, so normally examiners, they mix these questions slightly, okay, but they are totally different. So I expect you that you are going to use elimination method and remain with the best possible answer. Okay, let's do that, and we'll be smiling. And as you're preparing for these exams, I've already said this, avoid selective study. All topics are very important. Okay, so your duty is to exhibit that you have understood the topics in question. Okay, each topic's got key terms and principles. I will show you. Each topic got key terms and principles, which you have to know. For instance, contract law. Okay, the key term there is basically to define what a contract is. A contract is an agreement entered into by 2 or more parties, right? A contract is an agreement, underline that word, entered into by 2 or more parties, okay, with the intention that it shall be legally binding and enforceable before the courts of law. This definition is from Sir Frederick Pollock in his writings for contract law, okay, but it's already there in your manual, so there's no need for you to look at those bulky textbooks. Follow your manual, okay? So, agreement, meaning that where there was no agreement, listen, for you to agree, to say that you've entered into an agreement, it means that there was some voluntariness from the both parties, and there was no intimidation or coercion whatsoever to any party, okay? Did you enter into that contract knowingly or unknowingly? Was there freedom of contract? Were you coerced? Were you intimidated? Sign this or else I shoot you. That's not a contract. Yes, it could be a contract because you've signed, but such a contract cannot be enforced. Remember, I said a contract is an agreement entered into by 2 or more parties with the intention. Intention is key. That it shall be legally binding and enforceable at law. So if let's say there's some misrepresentation, you lied to me that this is the BMW 360, when in fact it's the BMW maybe 1908 model. You lied to me. It means that you misrepresented facts to me. Though I signed, such a contract is basically vitiated by that lie. when it comes to enforcement, it won't be enforced. So look, to make contract law is, the entire contract law is actually anchored on this definition. Yes, a contract is an agreement. Was there consensus ad idem? Was there a meeting of the mind? If not, forget. That's not a contract. Yes. If you crook me, you make me sign a document by malice, I'll plead my own defense. Okay? If I think maybe I'm signing for maybe a Panasonic camera and then you bring me an old Gigo thing, okay? Because you disguise yourself, maybe I will just plead mistake. These are vitiating factors which makes it impossible for a contract to be maybe enforced at law. Yes, it must be legally binding. If let's say you are dealing with maybe in one of the cases which is right there in the Zica manual, look at it. You are dealing maybe in drug trafficking, and you've hired me to deliver your drugs. Then as I'm passing through somewhere, some guys corner me and they get your drugs and run away. You cannot sue me for breach of contract. Yes. And I cannot sue you to come and pay me in courts. Because drug trafficking is an offense. It's illegal. Okay? You hire me to kill a person. Murder is an offense. It is illegal. So such contracts cannot be enforced. Yes. In one of the cases, here you discover, yes, some of you have read it. Maybe you've been laughing about it because that case involved a man who had a caravan. Okay? He had his own caravan. Then this prostitute came and hired that caravan. You read that case. It's there in the manual. After some few months, the caravan was destroyed. I don't know what has happened in that caravan. You should know better. So, look, the owner now wanted to sue that lady for the damage of the said caravan. When the court discovered that, no, in fact, the core business for that hiring was prostitution, such a contract could not be enforced. The man lost out because it was an illegal contract. So there must be some agreement entered into by two. If there are two people entering into a contract, it is called a bilateral contract. If there are three people entering into a contract, it's called a multilateral contract. Okay? But there must be some, maybe what we call what? Consensus ad idem, meeting of the mind somewhere. Okay? You must know what we are signing. So, those are the key terms: agreement, two or more parties, intention, legally binding, enforceable. Know this. Then you are done. So you marry now the vitiating factors and the elements of contract. If you see that there was this maybe lie here or misrepresentation or a false statement or there was a mistake or there was some illegality, those make those contracts non-enforceable. And now you can sue for damages occasioned. Okay, you look at the Zica manual, each topic it has some remedies. They are there. So read, start now, and don't wait until it's too late. Like I said, you cannot prepare for this examination in 3 weeks. Now let's look at this short scenario. Mulenga advertised the tractor John Deere 2015 model for sale on 1st January 2020. The advert read, once in a lifetime offer, tractor for sale John Deere 2015 model, offer valid for 48 hours. Okay? ZMW 35,000 cash only. Chanda sees the advert and calls Mulenga, instructing him to reserve the tractor as he was going to pay the following day. Charlo decides to rush to the shop, okay, and signs off a check which he left with the shop attendant. One fortunately did not inform Mulenga. Ruth does an electronic transfer and calls the shop without success. He sent an email to that effect. The same day, Mulenga decides to take his tractor to the auctioneer. Before the auction, Muzo offers ZMW 30,000 cash as opposed to the 5,000 original price. Mulenga tells Muzo to wait as that was fair enough deal. The auction begins and Mablo offers ZMW 50,000. But before the javel falls, the wife to Mulenga pushes off the husband who collapses and dies. Yes, the wife now refuses to sell the tractor. The parties are up in arms. Everyone claims to have entered into a contract and are claiming the deliverer of the said tractor. Advise the parties. This is what you are likely to find. But like I said, if you understand the principles, just from this reading, you will know that it was an invitation to treat. Do you see how clear it is? Simple. So was there a contract here? And was there a payment made? What are the terms of the contract? Because now you'll be required to advise. So in your mind, have the definition of a contract. I've already given you that. Analyze the situation at hand and apply the principles thereof. Okay, the issues are as follows in summary. Mulenga advertised. This amounted to what? Invitation to treat. Okay, define this term in the exam. Yes, look at the terms of the advertisement. It said the offer was valid for 48 hours. Did everybody make and attempt to pay within 48 hours. If it was beyond that, the offer was actually not valid. Yes. Okay. So mark this in the exam. Go to the facts, underline the validity of an offer is there in the Zica manual. Look at it. Okay. So if you are dealing with the validity of contracts, please look at that chapter in the Zica manual. So Chanda calls to reserve. Was there a contract? No, there was no contract. This was not sale by reserve. It was sale by strictly cash. Okay. So strictly cash sale are not reservations. So Chanda signs off a check. There's no contract was from there. A check is not cash, by the way. The wording was very explicit. Strictly cash, not checks. Okay? So these are the key issues which lecturers look for. Okay? So then Ruth does an electronic transfer. There was no contract here. This does not match the terms of the advert. It is strictly cash. How together? Then Moose offers 30,000. This is counter offer. You saw it in the case of Wide and Range. Some of you are reading. You have seen it. It's there. Okay? Then Mablo, at the auction, that incident, you look at the facts yourself. There was no contract there because the jive will never fail. Okay, so the conclusion is that there was no contract. But now you are required to advise all the parties. Okay, you can't say there was a contract. There was no contract. Right. So I hope you have gotten that. You can look at the sample answers which have been provided for. Okay. Now, what are the common mistakes which are done by you guys in these exams? Failing to identify key issues. Like some of you, from the scenario you have just given, maybe you are struggling to identify those key issues, but I hope this presentation will assist you. Failing to apply the law, okay? I've given you cases and I've applied the said cases to the facts. Failing to conclusively answer the question. If you've been asked to advise all the parties, identify the parties and advise them accordingly using principles of law. Are we together? So no case is referred to at all, or even the principles in the cases. If you write a general overview, unfortunately you fail, because the module which you're relying on, which you're using, is not general. It's not a general module. Okay? So, that's the example I've given you. There are several of them which I would expect you to find time and look at. Okay? For instance, let's assume Mulenga sold the tractor and it is discovered that the tractor is a 1996 model as opposed to 2015 on the advert. That is misrepresentation. How to get? So what do? Go and read misrepresentation and okay, the Zica manual. You discover that a misrepresentation is basically a false statement made by one party to the other with the view of inducing that party into entering that contract. So if you do that, there's some inducement. Then look, there's no meeting of the mind there. The advert is saying 2015 model when the actual vehicle is the 1996 model. So there's no meeting of the mind. The terms stated and the mind must meet somewhere. Then you'll be good to go as a student. Okay. So let's say you want to understand unit 1. Which I have already maybe brought to the fore. These are just sources of law in Zambia. Zambia is a dual legal system. This you must know by now. Okay? We practice common law and customary. You can own land under custom. You can own land under statute. Okay? You can marry under statute. You can marry under custom. Okay? So these are some of the issues which you're supposed to understand. So a source of law, like I already said, this is where the law is found. For instance, statutes, precedents. Okay, precedents. Like, for instance, the law on negligence. It was founded, the principle on the law of negligence was founded in the case of Dono and Stevenson. Okay. Lord Atkin there brought out key issues. So just read it from the Zica manual. Don't go to the main texts. They may be too bulky for you. But the Zica manual has been summarized. The principles are there. You'll be good to go. What constitutes custom? You have seen this case. It is Ganig versus Jairus. Have a time and look at it. Okay. The application of international law in Zambia, please look at the case of Felon and Zalga versus Zambia Sugar. Yeah, this case involved some ILO legislation, International Labour Organization legislation, which Mr. Nanzaloka was trying to move the court with after he got dismissed by Zambia Sugar. The court there ruled. Yeah, so don't give me all the facts. The court there ruled that international law is not applicable in Zambia once it has been domesticated. Yes, ratification at the UN Convention does not amount to domestication. It only becomes enforceable here once it has been domesticated. And how do you domesticate the law? When our parliament make it, enact it into an act here. Yes, only then. So you are good to go there. Read that case. Okay. So I'll give you one of the samples and so forth, but I implore you to look at the Zica manual and look at the sample questions and sample answers given. using the approach I've given you. Okay? So you are supposed to apply your mind. Okay? I've already explained how you deal with the sale of goods contract. Okay? Define a contract of sale and distinguish it from other contracts or other sale agreements. Do that. Know when a contract is concluded under sale of goods. Know it. Okay? When the property in the goods moves. Okay? At some point, when the goods have been identified, once you identify the goods, the property in the goods, okay, move from the seller to the buyer. Those are the parties. Are you seeing that even the parties, they are different? Because in contract law, simple contract, there's offeror and offeree, but contract under sale of goods, that's where you find the buyer and seller. If you look at the definition under section 1, subsection 1(3) there, it gives you clear-cut definitions of the sale of goods contract. So try and do that and distinguish it from other contracts, okay? And like I said, look at section 18 of the Sale of Goods Act religiously. Do that, and you'll be good to go. So, understand key sections in the sale of goods. But the main section is section 18. Section 14 deals with issues of mercantile quality. Start from section 12. Okay? Those are terms which are expected to be in any contract. If you include them, you're okay. If you don't include them, by implication, they are part of the contract. The law deems them to be part of the contract. Okay? So, read section 12 to 18 of the Sale of Goods Act. You can go up to section 30 there. You understand the sale of goods in full. But I don't want you to read the whole act. Just go for these key sections which are actually in the Zica manual. Then you'll be fine. Okay? So the Sale of Goods Act looks at what point did the property and the goods move, in summary. Okay? When the goods are identified, when they are appropriated to the contract. Okay? Did the said property move from the seller to the buyer? Under what circumstances do the said goods move? And even what amounts to goods has been defined in the Act, colleagues. So what you may call goods may not be goods at law. Yes. Yes. So I expect you to look for the definition, okay, of what amounts to goods at law. It's there in the Act. That should be your homework for today. Do that. Okay. So now, like I said, when you're dealing with employment law contracts as a student and you're preparing for the exams, appreciate the formation of contracts as a student. Number one, distinguish a contract of service from a contract for service. This question gives drama to students. And the reason why you mix up concepts is because you don't prepare adequately. So I will implore you to have a separate paper where you can write the characteristics of a contract of service and a contract for service. Then you'll be good to go. Okay? Because liability is dependent on under which contract is the employee performing his duties. Principles are different. If the person is an employee of the company, remember I said they are indemnified. But if the person is an independent contractor, they are liable for their activities there. So for any breach, commission and omission, they are fully liable. But these are experts. Okay. So explain the duties of the employer and the employee. Do that. They are categorically stated in the Zica manual. Do that. So appreciate the rules surrounding this contract thereof. You should do that. Okay. Look, this is business law. And you deal with employees and so forth. So you have to take keen interest in this. Okay? You should do it. So explain also the concept of vicarious liability and understand this topic. It is highly examinable. Yes. I've given you a leakage in advance. It is highly examinable. Yes, so do that. Look at it. Then you must understand the concepts, and Zica exams are designed to test your competencies in all these areas. Okay. The duty of you students is to fully understand and apply the law to this subject matter in full. Okay. So understand how the contract is formed up to dismissal. All forms of dismissal, you should know them. There are some few cases which you have included in the Zica manual. They are there. Read them and see what really happened. Distinguish fair dismissal from unfair dismissal. Okay? Redundancy contract, issues of retrenchment. Look at all those issues. They are there in the manual. Now that I said, you must understand from the beginning as to what constitutes this contract. Okay? Look at the ways this contract come to an end, and then you will be okay. You will not struggle much. Okay. There's a scenario which is basically on the Zica website. I want you to look at that scenario, and you find that Section 108 of the Employment Act, as it was then, was kicked in here, but I want you to refer to the Employment Code of 2019 now. How does the law treat unfair dismissal? Yes, find time. Look, you're a business student, and from time to time when these things are emerging, you'll be expected to be up to date. So look at that Employment Code of 2019, and then you'll be good to go. All right. So you must always find time to read the Employment Act. Go through it, go for key provisions, okay? And remember all principles which are in line with the questions asked in the exam. It is a must-do thing. So find time and do that. So for agency, I've already given you some guide. There's the principle, and there's also an agent, and also the underlying principles. So look, always have in mind that an agent can act for the principal in all circumstances, and the principal can either be you as a natural person, as a student, or an artificial person. Artificial persons are those who have been incorporated and they exist as such. Those are companies. So do that. Okay. I have this example, a short example. Kangwa is a full employee of GT Limited, a farming company. Just that line. It tells you that now Kangwa is basically an agent of GT Limited. So you must understand the duties of an agent and the duties of a principal. In this case, GT Limited is the principal. Okay, and Kangwa is basically an agent. So if you understand the common law position of the principal obligations of the principal and also the obligations of the agent, you'll be good to go as a student. Okay, so the question goes, he's a transporter of tomatoes to and from various centers and markets. One day his truck broke down in Mawe area, 30 kilometers from the market. Due to load shedding, his phone went off and he failed to reach the boss. He eventually sold the tomatoes at half price to avoid them getting bad. Okay? Can this decision by Kangwa be justified by law? The answer is yes. Because what he's doing everything in the best interest of the company. Okay? Who in this case is the principal, who in this case is GT Limited. Okay? So that's another example there. Find time and look at it. Okay? So students must appreciate the relationship which agency creates between the principal and the agent. Okay? So find time and look at that. So the most questions they will demand that the student define agency first. In fact, you do yourself justice if you always start by that. Start by defining key terms, agents. Then identify the type of agents in this scenario. You remember the different types of agencies, right? So look at them. Discuss the key elements of any type of agency which you have found out to be the one being under examination in the exam room. So do that, colleagues, without any delay. Okay, so I expect you to address your mind with these things. Now, when it comes to partnerships, as I've already said, okay, students, you as a student, you must understand the whole topic on partnerships. Are we clear? Understand the whole topic on partnership. Deal with formation of partnerships, and I've already said that a partnership is entered into by natural persons to begin with, and number two, it is also entered into by corporations, companies which have been incorporated. Deal with the formation of partnerships, explain the types of partners, describe the features of partnership deed. What are the features of partnership deed? How do you find these things is in the exam? Refer to the Partnership Act of 1892. We have it in this country. You can even download it. Okay. Understand the rights, obligations, and liabilities of partners. Explain how partnerships come to an end. If one partner dies, what happens to that partnership? Okay. Looks also at limited liability partnerships. That's all. Yes, that's all. Start studying. It is as simple as that. Okay. So, the general overview, if you go to the Zica manual, I've already alluded to this fact. You'll find that the sample questions are there and also the sample solutions. Okay. So, look at the sample solution after you've read the topic in full. And after reading the topic in full, look for the sample question. Deal with the sample question fact by fact. Answer it. After answering that, refer to the sample solution. Then you'll be good to go. Okay. Understand the liability of partners in a firm. Appreciate the subject. apply the subject, advise the parties. Then you'll be good to go. Okay, so what are the common mistakes which students always make? What are the common mistakes which students always make in the exam? General mistakes. These I have noticed from the time I started marking, and I keep on seeing them. Most of you don't finish writing your exam, and as such you are affected. You lose 20 marks before you even submit your paper for marking. So you're being marked out of 80. And there's no way you can get 8 out of 8. It's not possible. Okay? Spending too much time on what you know. Big risk as a student. Don't do that. Balance off your time. Answer all questions. The instructions are that you answer all questions. So do that as a student. And you'll be good to go. So failing to answer questions, before you answer, ask yourself, am I answering the question before me? If you answer it to the affirmative, then you are good to go. Are you answering the question before you? Answer the question. And look at the marks allotted. And then answer in a proper manner. Okay? Proportionate your marks accordingly. You can even mark yourself in the exam. I think here I've gotten everything. And you can only do that if you as a student you have prepared adequately and on time.
And you can only do that?
You can only do that as a student if you have prepared on time and adequately. And like I said, do not start studying a month before the exam. It is dangerous. Right now you've registered for this course and you have got all the time you need. Start studying. This is a professional course. Okay. So, in conclusion, the understanding of the business law course is meant for you to go and perform well in the industry. No wonder it is tailored the way it is tailored. You must understand the obligations and liabilities arising from the operations of each and every business on a daily basis. I hope this guide has assisted you. Until next time, thank you very much.